Thank you for attending the meeting of the Bills Committee. We have a quorum. I call to order the meeting of the Bills Committee. I now ask the staff members to invite representatives of the administration to come inside the conference room. Members who wish to speak, please press the request to speak button. All right, we shouldn't waste any time, Miss Dr. Tik Chi-yun. Yes. When we discuss the bill, let me first declare that I'm not a member of the Bills Committee. I have a suggestion, however. This issue is of great concern for members of the public. Will we have a public hearing for members of the public to express their views? That is just my suggestion. I believe within this session we will discuss the relevant arrangements. All right. Let me first welcome representatives from the administration. I will first ask the representatives to give a PowerPoint presentation on the bill. Permanent Secretary, Ms. Doris Ho, you will first give an introduction, right? Yes, Chair. Thank you, Chair and members, for forming the Bills Committee to scrutinize the protection of the Harbour Amendment Bill 2024. In relation to the proposed amendments, we have consulted the panel on development before. We have incorporated feedback from LegCom members. We will today discuss the relevant proposed arrangements that are fine-tuned amendments. I will have Ms. Leonie Lee give a PowerPoint presentation, but before she speaks, I'll give some background information. Now, with the protection of the Harbour Ordinance, Chapter 531, we have a presumption against reclamation, and it applies to the whole of Victoria Harbour. The problem is, there is such a presumption, but the ordinance is quite simple. It only has 4 sections. It does not include a specific mechanism to tell with certainty how the presumption can be met or can be rebutted with the overall public need satisfied, test satisfied, overriding public need test satisfied. And regardless of the scale, regardless of whether the works are temporary in nature or permanent in nature, regardless of the intention, works within the Victoria Harbour, including those that can enhance public enjoyment of the harbourfront, cannot be taken forward. For non-permanent reclamation projects, in particular for transport infrastructure, if a working platform is to be constructed for the construction of transportation infrastructure, it is non-permanent, but it is still subject to the overriding public need test. In the past few years, we have seen significant development in the harbourfront. The public enjoys the facilities in the harbourfront and thus has higher expectations of facilities at the harbourfront. We now really see the restrictive regime of the ordinance. We want to promote a water-friendly culture. We want to construct, for example, landing steps or enhanced pier facilities, and these cannot be taken forward because of the restrictive nature of the ordinance. It is said repeatedly by the government that there are no plans for large-scale reclamation within the harbor to form land for housing, commercial, or industrial developments. The intention of amending the ordinance is to improve connectivity while preserving the harbor. We also want to remove restrictions to have a streamlined mechanism so that for small-scale reclamations or harbor enhancement reclamations, a streamlined procedure can be adopted. And we want to also apply streamlined procedures to non-permanent reclamations. As said earlier, we have consulted the panel on development on the proposed amendments. We have had frequent exchanges. We have also consulted the Harbourfront Commission. Last year, we have conducted a 5-month public engagement exercise. All in all, the proposals received cross-party support from the LegCo, and most Harbourfront Commission members were supportive of the proposed amendments. The public was also generally supportive of the proposed legislative framework. We have incorporated feedback from various parties in the fine-tuned proposals we present today. I will now let my colleague speak on the details of the proposed amendments. Thank you. Who is going to speak? Ms. Lee. Thank you. Chair, thank you, Permanent Secretary. I will now talk about the details of the proposed amendments. The Permanent Secretary touched on the fact that we had a definition of the boundaries of the harbor in the Interpretation and General Clauses Ordinance. It is shown on the slide here in the pink area. To the west, it would reach Tingkau. On the Hong Kong Island side, it would go through Green Island to Kennedy Town. And then to the east, it would be Lake Yunmun and Shao Kei Wan. The ordinance was enacted in June 1997. It consists of only 4 sections of simple wording. It is said that there is a presumption against reclamation in the harbor, and I'm sure members are aware that there have been 2 judgments in 2004 and 2008 that said in particular the presumption could be rebutted by establishing an overriding public need test for reclamation. Also, there is a requirement for cogent and convincing material CCM to be prepared to justify the overriding public need. The ordinance has been enacted for decades now. We have observed several major problems. The Permanent Secretary touched on this before. We do not have a specific mechanism to ascertain whether a reclamation proposal can fulfill the overriding public need test to rebut the presumption. Also, this presumption is applied to all harbor reclamations across the board, even if they only involve small-scale or non-permanent reclamations. For the first problem, we propose to have a clearer mechanism. For harbor reclamations not exempted from the presumption, there will be a clearer mechanism to assess and determine whether the presumption can be rebutted. For the second problem, we will provide a mechanism to exempt harbor enhancement reclamations and harbor non-permanent reclamations. These are in general smaller scale reclamations, and they can be exempted when they meet certain criteria from the presumption. This should relax the relevant restrictions so that they will no longer be subject to the presumption. So we mentioned the two directions here. For the other amendments, we'll go into the details later. On clearer mechanism for protecting the Victoria Harbour. This is applicable to harbour reclamations not exempted from the presumption. That would include works for major roads or infrastructure involving reclamation. The high threshold of the presumption will continue to apply. What does the threshold entail? 1. There will be an overriding public need for the reclamation, and the need is compelling and present. There is no reasonable alternative to the reclamation, and the extent of the reclamation does not go beyond the minimum of that which is required by the overriding public need. And these three components have had reference to the 2004 judgment, and we have incorporated what was said in the judgment basically in the proposed amendments. The statutory arrangement would also include public participation, so the public will be able to express their views. So who can make the final decision? We suggest that the Chief Executive in Council is to determine the rebuttal of the resumption, having received the relevant information as well as public views. So this is the first part of the proposed amendments on a clearer mechanism for protecting the Victoria Harbour. 2. Streamlined mechanism for harbourfront enhancement. We propose to have two categories. 1. Harbour enhancement reclamations, HERs. So these would include piers, viewing decks, and breakwaters. There are in total 14 categories under this type of reclamations. These are works mainly for enhancing harbourfront facilities as well as connectivity. We will have a ceiling for the specified area of the structure, feature, or device concerned. It cannot exceed 0.8 hectare. How did we derive this figure? We have had feedback from the trade. We had also reference to previous projects. We believe with its ceiling, it should be able to cover works for the relevant structures, features, or devices. The reclamation must also be in the public interest. For the second type, it would be non-permanent reclamations and PRs, as the Permanent Secretary said. Say for the construction of a working platform for the construction of transportation infrastructure, they will be removed after the construction of said infrastructure. For example, for the Central Kowloon Route project, you can see in stage 1, a working platform was constructed in Kai Tak so as to construct an underground tunnel. You can see that after stage 1, the structure was removed, and in stage 2, another temporary working platform was constructed for phase 2 works of the project. And once the works for the Central Kowloon Route were completed, you won't see any structure on the surface of the harbour. As such works are non-permanent, therefore we will impose a restriction on the period of construction to be not more than 7 years. We have also had reference to previous projects when deriving this figure, and we have also incorporated the feedback when we consulted the Legislative Council or the stakeholders, as well as the public, this figure should meet the relevant expectations of stakeholders and the public. The works must also be in the public interest. The Financial Secretary will make a final decision on the exemption of the presumption for the relevant projects. The project proponent would have to submit the proposal to the Financial Secretary. The Financial Secretary would then have to consider the relevant factors, the area, the period of construction, as well as public views to see whether the project can be exempted. We have talked about 3 types of works, and now we want to compare the workflows under the different mechanisms.
Let me first talk about Harbour reclamations not exempted from the presumption. That is the column on the left-hand side. Specified officer have to first prepare a report to explain why the reclamations have an overriding public need, and the specified officer SO will also have to arrange for public inspection of the overriding public need assessment and comments for 60 days. And we also ask the SO to consult relevant stakeholders such as the Harbourfront Commission and district councils. This is an administrative requirement, and we will encourage the project proponent to consult the relevant stakeholders. And within 5 months, the SO will have to submit the OBNA report and comments received to Chief Executive and Council. Lastly, the Chief Executive and Council will determine whether the presumption can be rebutted. This is the high threshold and stricter kind of procedures. Over the right, the blue and green procedures are the more streamlined ones. First of all, SO have to prepare materials for application of exemption, and there is also an element of public participation. After that, the SO will have to submit the application to the Financial Secretary, and then the Financial Secretary will decide on whether to grant the exemptions having regards to the factors that I just mentioned. And the exemption can be granted with or without conditions. As I mentioned, there is a period that is restricted under the MPR, so the SO will have to submit a progress report annually to see if the works can be completed within schedule. As we have streamlined some of the mechanisms, in case of non-compliance, the Financial Secretary should have means to follow up on them. For example, under HER's Harbour Enhancement Reclamations, if conditions is not complied with, such as the commencement day of the work and the part of space to be opened for public use as temporary pedestrian passage is not opened by the project proponent, then these are counted as non-compliance. For non-permanent reclamations, SO have to commence their works within a certain period of time, and they have to submit progress report. If they don't comply with these requirements, then the Financial Secretary may suspend or revoke the exemption. After the exemption has been suspended or revoked, the works cannot be continued to be carried out. We do offer some buffer. If safety hazards is involved, then the reclamation can continue to be carried out. The Financial Secretary may also direct to reinstate the harbour affected by the reclamation or other directions that he or she considers appropriate. In case of suspension, if the non-compliance situation has been rectified, the Financial Secretary may lift the suspension. We don't think that we will invoke these penalties, but we still think it's appropriate for us to provide for such a mechanism. There are also other amendments. We will clarify that protection and preservation of the harbor is the purpose of imposing the presumption against reclamation under the PHO. And we think that the original wordings were not clear, so we propose to make some amendments. And also we want to provide for a clearer definition of reclamation by adding a definition of the term seabed or foreshore in the PHO. The word seabed or foreshore are already here in the existing ordinance, but we have not provided for any definition of them. So that's why we want to follow the definition of these two words in the foreshore and seabed reclamation ordinance to make everything clearer. So what kind of works may be benefited from the amendments? Say if the bill is passed, we will be able to take forward a number of projects. For example, at the harbourfront in Kennedy Town, over the left hand side, you can see that there is no pavement along the coastline. A lot of pedestrians want to appreciate the sunset, and that's why they walked out onto the carriageway, and they're very close to buses or heavy goods vehicle very often. So we propose to construct a boardwalk, because boardwalk is a kind of items under the schedule of exemptions. We want to enhance the connectivity of the harbour in Kennedy Town. Another works that may benefit is the harbourfront along Hong Kong and To Kwa Wan. At the uppermost circle, this is an existing waterfront gas facility site, and is next to Grand Waterfront. People cannot actually reach this point. We want to improve the connectivity by building a boardwalk. Now, onto the circle in the middle, this is the Kowloon City Vehicular Ferry Pier. It has been abandoned currently. Well, its pier is also one of the items under the schedule of exemption. We want to perhaps redevelop it, as it's a historic building. We will try to see if we can revitalize it. At the lowest circle, that's the Green Island Cement Pier. Again, this pier has been cordoned off, and a part of the pavement cannot be used. After the bill is passed, we will see if we can make this part of the harbourfront more accessible. That's all from our presentation. Thank you. Thank you, Ms. Lee, for the detailed presentation. Now it's the time for questions. I'll read out the names of the members who have pressed the button. They are Mr. Chan Hock-Fung, Mr. Tan Ka-pil, Mr. Lee Chan-kan, Mr. Yang Win-kit, Dr. Dick Chi-yun, Mr. Lau Chi-pan, Mr. Yu Pak-lam, Mr. Andrew Lam, Reverend Peter Kuhn, and Mr. Stephen Ho. Each member will have 5 minutes. Mr. Chan Hock-Fung. Thank you, Chairman. I've been waiting for this amendment exercise for a long time, and I used to be a Central and Western District Councillor, and I've been one for over a decade. For the boardwalk along New Praia in Kennedy Town, well, because of the protection of the harbour ordinance, we were not able to construct one there. Every day we see a lot of people taking photos at the spot. If we can construct a boardwalk and connect it to the harbourfront at Saiwan, then that will be a very enjoyable place for the people to visit. I hope that the boardwalk can be constructed as soon as possible. We've been trying to protect the harbour. Victoria Harbour is our invaluable asset. We try to refrain from reclamation as far as possible. I see that the amendments proposal is drafted along the line. Now, there are some 10 odd items that are allowed under the exemption mechanism. For minor works, you mentioned specified officer. Are specified officer government employees or civil servants? What about private organizations? Say if private organizations want to construct a pier in front of their buildings, can they do so? Do they have to open the relevant pier or structures to the public? I think that you need to tell people that, because if the structure or land reclaimed is only enjoyable by the private organizations, then that would not be ideal. I think that the reclaimed structures or site must be opened to the public, and that should not be exclusive to private use. Second, for example, if I am granted to construct a pier for my first application, and then I could perhaps submit another application for landing steps, and could our Victoria Harbour be shrunken along the line, or when more applications are granted? Say, for example, will we provide for that a project proponent should not be able to submit another application within 5 years upon the first application being granted? We should not allow for different departments and organizations submitting different applications for reclamations, so that as a result, there will be different reclamation works going on in the Victoria Harbour. I want to avoid that. Mr. Tankapiu, please adjust the lighting at your table, because now it's pointing towards me. Ms. Ho, Permanent Secretary. Thank you. 2 questions. First of all, specified officer is defined under the legislation. They are government officials. Although specified officers are government officials, but for the streamlined mechanism that apply to also projects proposed by private organizations. So private organizations may submit non-permanent reclamation or HER applications to the Financial Secretary. If the Financial Secretaries think that the presumption can be rebutted, then the specified officer will process the application on behalf of the project proponent. Say if we are to construct a road, then we have to publish a notice in the Gazette. The one who published the notice in the Gazette will be the government officials, but the road may be constructed by a private organization. Second, I completely agree with your point. This streamlined mechanism is also open to private company and their harbor enhancement projects. The Financial Secretary will have to look at whether public interest is involved when he decides whether or not to grant the exemption. The Financial Secretary will see whether the structures to be constructed along the coastline will be open to the public before granting this exemption, and the public interest is a factor to be considered, and that's already provided for in the bill. The Financial Secretary is also empowered to add conditions to the exemption, and one of the conditions could be that the structure must be open to the public. And the project proponents must follow the condition, and the condition will be set out in the land lease, and that would bind the project proponent. The second suggestion, well, I understand your point. You don't want to see multiple reclamations within a small area. We do have a mechanism to avoid this. When the financial secretary scrutinizes the HER or NPR applications, they have to look at the public interest involved, and the financial secretary will also have to see whether there are similar projects in the vicinity. We understand your point. So when the financial secretary scrutinizes the application, they will also have to consider the relevant factors. You ask if we will set a restrictions of 5 years of banning HER NPR in the same area within 5 years upon the first application being approved. Well, if the restrictions is too stringent, then there is no flexibility. I don't think that we should provide for that in the laws, but we will offer technical circulars and guidelines. Perhaps we will add that in the technical guidelines.
All right. With the points raised by Mr. Chen Hofeng, I would like to clarify something. Does the government own the service of the harbor? There is no private ownership, right? Perhaps you can give me a reply later. Yes, I will give you a reply later. Thank you, Mr. Tan Ka-Pu. We have all been waiting for the proposed amendments. Since we're in our first round of questions, we can go broader. In fact, Ms. Alice Mack, before she was Secretary for Home and Youth Affairs, she talked about this already when she was an FTU member. Of course, we have the boundaries of the water or the harbor in law, but do we really need to stick to these rigid guidelines, say for Tin Khao? Or let me say this, in Kowloon East, Kai Tak was reclaimed space. The water body within is not natural in a sense. In Sha-Tin, it would be equivalent to Xingmun River. I think the across-the-board approach in the ordinance is not ideal because it has restricted the use of the public with the water bodies in the area. So I want to ask if there is any room for amending the boundaries of the harbor, or is it set out in previous judgment that the boundaries of the harbor cannot be amended at all? Also, can we rename the ordinance? Can it be something like making good use of the harbor? Because when you say protecting the harbor, it is about pretty much not making any changes. It should be about maximizing the value of the harbor, perhaps the economic value of the harbor. All right, so these are my overarching principal questions or suggestions. Now, with the Kai Tak Cruise Terminal, it has not been doing well for many years until we are talking about developing an international maritime center in Hong Kong. I'm just asking if it is possible to have a pedestrian or a cyclist bridge across Kai Tak. For those who are concerned about the development of Kai Tak or CBD2 in Kowloon East, they really want this. So will this be possible? We recently have many water-friendly photo-taking hotspots such as the East Coast Park. There is this water-friendly promenade that is well received by the public. So this really demonstrates that with harborfront enhancement works, it does enhance public enjoyment. Now with Annex B, we have breakwaters. Breakwaters can be quite big, so is it the case that no breakwater exceeds 0.8 hectare? Will the area restriction impede the construction of breakwaters? We really need breakwaters because we can see that in the East Coast Park it is well received by the public and it indeed promotes a water-friendly culture. Thank you. Permanent Secretary. Thank you. The member asked 4 questions. The first on the definition of the boundaries of the harbor, whether the boundaries can be amended. The boundaries of the harbor, the section is included in Chapter 1, Interpretations and General Clauses Ordinance. We do not have any plans to amend the boundaries of the harbor in this exercise. We want to protect and preserve the harbor within the confines of the protection of the harbor ordinance. We therefore have no plans to amend the boundaries of the harbor as set out in Chapter 1. The boundaries of the harbor were enacted 20 to 30 years ago, and I think there is a public expectation about this. We do not have any plans. We also note the member's suggestion on renaming the ordinance. Now, on the suggestion about a pedestrian or cyclist bridge, it will cross the water body from one side to another side. It is not included in the 14 categories of HERs. We did not include bridges for certain considerations because bridges are relatively large structures, regardless of whether it is a pedestrian or cyclist bridge. For a vehicular bridge in particular, there will be concerns from the public. Actually, regardless of any bridge it is, there will be public concerns. But it does not mean the projects cannot be taken forward altogether. It is just that it will be subject to a higher threshold. A report would have to be submitted for a project that we believe will attract greater public concern. We think a high threshold is in order. On breakwaters in To Kwa Wan or the breakwater in Causeway Bay typhoon shelter that you mentioned, the area occupied is around 0.8 hectare. So we believe the ceiling of 0.8 hectare should not restrict the construction of breakwaters. Thank you. Mr. Lee Chen-kang. Thank you. I agree with what Mr. Tankapu said about renaming the ordinance because we should really focus on the aspect of maximizing the use of the harbor. We have different needs in development, and when we look at other places, if they have water bodies, lakes, for example, in Shanghai, Huangpu district, or in Singapore, they have made good use of their harborfront or waterfront, and in different places, really, they have been doing that. And we really need to maximize the use of the harborfront by the public. Do you know, or have you observed, we really don't have any harborfront F&B or entertainment facilities? With the proposed amendments, not only can we enhance connectivity, we will be able to remove restrictions for the facilities to be put in place that will bring greater convenience to the public or even visitors. Now, the justifications say that before there was an across-the-board approach with reclamation within the harbor. There is unjust workload, and in fact, since the 2004 judgment, we have only had 5 projects taken forward. So I want to ask, can the government elaborate on this? How much time, human resources, or resources in general were wasted? If you give us the details, the public should be able to understand that there is a need to remove the relevant restrictions so as to facilitate development and benefit the public in order to create economic benefits. With the proposed amendments, will the coastline of Hong Kong be affected? Thank you, Permanent Secretary. Thank you, Chair. For the first question, with the protection of the Harbour Ordinance, we talked about it having an unreasonable workload. I can perhaps give more details later with the disproportional efforts. Say with the East Coast Park Boardwalk that will soon be commissioned. We had to, for this project, to show that the overriding public need test is satisfied. Not only did it involve government employees, we had to engage consultants. So for this project outside City Garden, there was much cost involved. We can give the Bills Committee the details after the meeting. As for the impact or potential impact on the coastline of Hong Kong, it would really depend on, subject to the passage of the proposed amendments, what the streamlined mechanism would actually allow in terms of projects. But I do not see or anticipate a significant change. The people of Hong Kong want to preserve the harbor as well. We are only taking forward projects for the enhancement of public enjoyment of the harbor front. With the streamlined mechanism, we will seek to connect the waterfront. We will perhaps construct landing steps to provide landing facilities for embarking and disembarking of passengers from vessels. We also want to have structures that would promote a water-friendly culture. These will enhance public enjoyment of the harbor. We do not think these structures will significantly change the coastline of Hong Kong. Thank you. Thank you, Permanent Secretary, for doing much about the East Coast Park Boardwalk within the confines of the ordinance at the moment. And we would like to thank you in advance for providing the relevant details of the project after the meeting. But I think we have to say that for different projects, there are different circumstances. So it would be on a case-by-case basis, really. Thank you. Mr. Yan Wing-kit, Thank you, Chair. I'm not a member of the Bills Committee, but when I was a district councillor, I have already been advocating for connecting the Harbour front. And in fact, for the 3 circles highlighted in one of the drawings or photos, I have already been advocating for the connection of such for 16 or 17 years. I have some comments to make, especially with the 0.8 hectare ceiling. How did you derive at the figure for the 3 circles in particular? It would already exceed 0.8 hectare. Or are you seeing that the 3 areas would have to be 3 different projects? I think you should clarify this so that the public would have a good understanding of this, and it will prevent future potential judicial review applications because things are made clear. You're now talking about having 14 categories of works. But these would also involve perhaps changes in the outline zoning plans, even for the construction of landing steps. How can you expedite the process so as to facilitate the taking forward of such works? I think the Permanent Secretary really has to think about this, because if you are to construct a boardwalk, while you have a streamlined mechanism, you still have to amend the relevant outline zoning plans, and then you will be able to take forward the relevant works. It would still take a decade or so to take forward the project. So even with the streamlined mechanism, we really have to make sure the process for amending outline zoning plans is expedited to resolve the delay in the process. Thank you.
Hi.
Ms. Ho, 2 questions. First, on the 0.8 hectare ceiling, as I've explained, will provide for in the legislation that when the financial secretary scrutinize application, they will have to look at what projects in the vicinity have been approved. We have this mechanism in place in order to avoid any project proponent breaking up large projects into smaller ones. When the bill is passed, we will set that out in our guidelines as well. We'll set out the calculation for the 0.8 hectares. The ceiling applies to each project, and we will provide for more details in our guidelines to be published in the future. Second, you talked about amendments to outline zoning plan. A lot of harbourfront areas are zoned open space. Say, for example, if you want to construct landing steps or harbourfront related facilities, as most of the harbourfront areas are zoned open space, these are considered subsidiary or ancillary uses. These works will be allowed without any amendments to the OZP. Let me give you an example. The boardwalk outside a city garden in the Eastern District, we did not amend the OZP there. How did we take forward the project? Well, we have to publish the works in the Gazette. Under the town planning ordinance, Cap 370, after the works have been gazetted, they would be deemed as the existing use or uses that have been approved. So for the works listed in the schedule, they will not be subject to any OZP amendments. I will not be speaking for the second round. Let me ask another question. For the area outside Grand Waterfront, you are going to construct a boardwalk there. I wonder if OZP amendments will be involved. Can we handle these in advance so that the project will not be delayed? Anything to add, Ms. Ho? Thank you for your suggestion. For the situation in Grand Waterfront, I don't think that the relevant OZP will have to be amended. If OZP amendment is involved, then we will try to speed everything up. I think that we all want the government to clarify about the town planning procedures, such as the 7-year or 8-year ceiling for non-permanent reclamations. Are they subject to the town planning ordinance purview? Because a temporary land would be formed that lasts perhaps 7 to 8 years. Are they similar to temporary structures on land? Please clarify. Next, Dr. Taek Ji-yoon. Thank you, Chairman. The intent of enacting the protection of the Harbour Ordinance is to protect our Victoria Harbour. The harbour is our invaluable asset, and reclamations brought about some negative consequences. I do think that we need to set a high threshold for reclamations. If we allow for all sorts of reclamation, then we're not protecting the harbour. And the court handed down 2 judgments. We need to protect the harbour. That's why we set a high threshold, and the court acted in the interest of the public when they handed down the judgment. Now, the government is saying that, well, the procedures is so cumbersome, we have to remove barriers. And now it is proposed that we vest the power of reclamations with the government. Now, the project proponent is usually the government, and also the government will be the gatekeeper. I don't think that this is reasonable. You said that the procedures create heavy workload, and that is disproportionate. I think that this check and balance is also problematic. On slide number 10, public participation is mentioned. But it is said that a specified officer will have to consult Harbourfront Commission, district councils, and stakeholders. I don't think that this is enough. Not only people living near the reclaimed structures will be affected, everyone in Hong Kong will be affected. By constructing boardwalks or other structures that may connect the harbourfront and that may make the harbourfront more enjoyable, but there are other people that feel differently. You don't even allow an opportunity for them to submit their views. Unlike the town planning board, they have a public hearing sessions. We don't have that in here. I hope that you would include more parties under public participation by saying that all members of the public will be allowed to write in, and there should be a public hearing sessions like the town planning board. With consensus among the community, there won't be any judicial review, because judicial review could complicate things. Ms. Ho. Thank you. I'd like to clarify one point. Under our proposed amendments, we are not transferring any power of the court to the government. The decision to reclaim has always lies with the government. Only when the government decisions is subject to judicial review will the court plays a part. And at that time, the court will hand down a judgment. The mechanism will be the same under our proposed amendments. Let's look at the left-hand side on this slide. This involves large-scale reclamations. The threshold is the presumption against reclamations. In the future, any large-scale reclamation will be subject to this presumption against reclamation as well. The project proponent have to compile a report, and this report will have to be made public. There will be a formal public participation mechanism. The specified officer must arrange the report for public inspections and comments for 60 days. Any member for the public, any person can submit comments on the proposed reclamations. Within these 60 days, anyone can submit a comment, and the specified officer will have the responsibility to submit the overall public need assessment report and the comments received to the Chief Executive and Council for a decision. So large-scale reclamations will still be subject to the presumption against reclamation. And we want to provide for a clear mechanism to regulate reclamation. And the Chief Executive and Council, after they've made the decision, that decision will still be subject to judicial review. And when there is judicial review, the court will make a judgment or make a decision. Over the right-hand side, these are small-scale reclamations. These small-scale reclamations are rather localized. That's why we think that we have to remove barriers and restrictions. If we follow the same mechanism that applies to large-scale reclamation, then we aren't really removing any barriers. So if the financial secretary thinks that the reclamations is in the interest of the public, and if the works is smaller than 0.8 hectares and is one of the works that are allowed in the schedule of the legislation, then the streamlined mechanism can be invoked. For the mechanisms on the right-hand side, that only apply to small-scale reclamation that allow a better enjoyment of the harbourfront by the people. And this is the essence of our amendments. So basically, stakeholders include members of the public. That's what you mean. Is that correct? Chairman, let me supplement. Harbourfront Commission, relevant district councils, and stakeholders. These are the people that will be consulted, but we'll also look at what people are going to be affected by the reclamations, and we will consult them. Please give me another 30 seconds. I'm talking about the right-hand side. I don't have any comments on the left-hand side. I'm talking about the right-hand side. My criticism is that you are the one to decide who to consult. Can I write to you if I am just a regular member of the public? Can I ask for a public hearing? Is there such a mechanism, Ms. Ho? Well, first of all, we don't have a plan for a public hearing. Over the right-hand side, we're talking about harbour enhancement reclamations and MPRs. They are smaller in scale, and that would not really affect the harbour that much. Despite this, we include a public participation element. In the mechanism, we are going to consult the Harbourfront Commission and the relevant district councils. Members of the public who are interested to give their comments, how can they do so? Well, we'll look into it after the meeting. Say, how can we collect more views from different people when we have a project? We will look into that.
Perhaps you can give us the details on public participation after the meeting. Professor Lau Chi-Peng. Thank you, Chair. While the scope is broad, we are focusing on the details of the proposed amendments. The bill is Protection of the Harbour Amendment Bill. As the name suggests, we are striving to protect the harbour. In history, the harbour has really helped the city prosper. Before 1997, we were discussing how to protect the protect the harbour. And the permanent secretary said the public had certain expectations to protect the harbour. And indeed, I think that is the case. I think we need these proposed amendments to change the mindset slightly. And I think perhaps the permanent secretary can lead a discussion on amending boundaries of the harbour in future, but this should not be included within this exercise. We have a 0.8 hectare ceiling imposed. I agree. There should be a restriction on the specified area. I do not remember the specific discussions that took place before, but it involved basically the general public. Now, with this change in the framework for public enjoyment, and the financial secretary is to decide on the exemption, it seems like this is a step backward because there is only one party involved in the decision. I do not agree with what Dr. Teck Chi-Yun said because that would be too onerous, but can we have a smaller committee that would be able to make a decision on exemptions? Of course, I understand that the financial secretary can make a professional decision, but we also need to make sure the public accepts the decision to be made. So is it possible we can have a body to make a decision on this? I think there will be time for us to flesh out the details in future. Regarding what Professor Lau said on the power to be exercised by the financial secretary, I think perhaps the representatives from the administration can elaborate more on the arrangement and the justifications for such. Thank you. As I understand, Professor Lau is advocating for a committee instead of the financial secretary making a decision on exemptions. Right now, in the proposed arrangements, before the financial secretary is to make a decision, relevant stakeholders will be consulted, including the Harbourfront Commission. The Harbourfront Commission's chairman is, the Harbourfront Commission is led by the Secretary for Development, and it has various professional stakeholders in the membership of the Commission. And we have receive great feedback from the Commission so far, and the views of the Commission will be referred to the Financial Secretary for his consideration of the decision. Well, I think setting up a committee is not ideal because when another member asked for the streamlined mechanism, it is to be made applicable to private projects as well. And there is a condition that it should be in the public interest. If this power is delegated to a committee, some may have doubts as to whether the power is exercised in a neutral manner. That's why we think the decision should be made by a public officer, because we can say in law what factors are to be considered by the Financial Secretary. But we do think that we need input from various parties. That's why we will have the specified officer consult the Harbourfront Commission, district councils, and stakeholders, and perhaps we should also have channels for members of the public to express views. I think we should do more in consultation to make sure the Financial Secretary would have comprehensive consideration of various views for a project. Thank you, Mr. Yu Patlan. First, I would like to declare I am a member of the Harbourfront Commission. The harbour is an important asset. It is also one of the most popular attractions. According to a survey of the Tourism Board, the Tsim Sha Tsui waterfront is one of the top 10 attractions that visitors would visit in Hong Kong. So it is really important to make sure we protect the harbour. We need to ensure that there is proper depth and scale of the harbour in order to have our cruise industry prosper. We also had naval vessels of different places, including those of the countries, visit Hong Kong. We should make sure that the Victoria Harbour would not become a Victoria River, as another member suggested. We need to, however, also make sure that there are proper facilities, for example, landing facilities, to complement the development of the tourism industry. If you visit the harbour front close to the Avenue of Stars at 6 or 7 in the evening, you would see a lot of people queuing to embark or disembark from or onto vessels. There is really a need to enhance the experience of the public and visitors by putting in place more facilities. Before an across-the-board approach was adopted, some smaller scale projects cannot be taken forward. Things have moved very slowly as a result. We really want to enhance the connectivity and the general public enjoyment of the harbourfront. There's a need to take forward the relevant projects. If we remove restrictions to facilitate such works, that would be ideal, and it is necessary. I believe the proposed amendments would remove restrictions, but I do understand some of the concerns voiced, whether there would be excessive reclamation. But I think the proposed amendments would still have safeguards in place that would allow the public or stakeholders to express their views. And that should be done. I do have some questions for the schedule or for the table. It says that for the right-hand side or the left-hand side, the Harbourfront Commission, district councils, and stakeholders will be consulted, but will you also consult the Legislative Council? I think that would be ideal. And specifically in Schedule 2, you talked about works to mitigate extreme climate risks. It is a bit vague. Can you talk about what these works would entail? Thank you. Permanent Secretary, thank you. On the construction of landing steps, the member actually voiced on multiple occasions that we should remove the relevant restrictions to take forward projects to construct landing facilities in the harbourfront. We do note your suggestion. For smaller scale reclamations, whether it is possible to consult the Legislative Council as well. We will think about this after the meeting. I think we really have to strike a balance. We are looking to streamline the process. So we would try to strike a balance between seeking views from LegCo members and stretching the period of time needed for consultation. You talked about device for mitigating extreme climate risks. We have a diagram here. So close to the coastline, when there is typhoon, when the water level is higher, we will need some structures to make sure the higher waves won't get up onto the shore. I want to ask this, since the 2004 judgment, at least from what I remember, there have been some details added, right? Do you have the relevant information? Perhaps you can give a response on this later. Mr. Andrew Lam. Let me say this. We have to think about what we are trying to do when we are talking about protecting the harbor. This may be an academic discussion. Should we try to protect the natural part of it or the artificial part of it? But even for archaeological works, it would involve excavation. Let's not go into the details here. I'm making this point because we have relevant ordinances before, such as in 1976 we had the ordinance relating to country parks. We also have an ordinance for the protection of monuments, the Antiquities and Monuments Ordinance. From a conservation perspective, for the two relevant ordinances to protect the natural parts, whether it's marine parks or country parks, you said specifically what is allowed in terms of development within those parks. With antiquities and monuments, you would preserve them, but it does not mean you can't even put a single screw in the building or the structure. So why is it that with projects of the Victoria Harbour, the court gets to decide on whether projects are to be taken forward instead of a specific body, like what is happening for country and marine parks as well as antiquities and monuments? With development, it is not about the law, it is about what is beneficial to society. And the town planning board plays an important role. With public participation, I want to hear the government's stance on this. With the passage of the proposed amendments, when it involves changes to outline zoning plans, or if it involves changes that may potentially have to do with town planning, would there be a public consultation process like what we have for the amendments to outline zoning plans or the town planning ordinance? I also heard that the government does not really object to the points made by various bodies. I want to ask this, since anyone can lodge a judicial review, if you do not have any measures put in place, how can you really prevent a member of the public or members of the public from lodging judicial reviews unless they are justified? Thank you.
Ms. Ho. 3 questions from the member. First, regarding the functions of the Victoria Harbour, it keeps changing. Initially, we focused on the functions of the Victoria Harbour. That's why on both sides of the harbour we have cargo working areas and terminals for cargoes, loading and unloading areas, so on. However, recently there's been a change regarding how people view the Victoria Harbour. Victoria Harbour still serves our economy, but I think that the people are now viewing the Victoria Harbour as a place for them to enjoy their time with their family members. So I think that the functions of the Victoria Harbour have changed towards enjoyment. You ask whether the Victoria Harbour is a natural resources or cultural resource. I think that depends. Different people may have different views. The member asked why the court makes the decision. Well, all along, the government is the one who decide on whether reclamations is to be done along the Victoria Harbour. The government initiate the project. The role of the court is that when there is judicial review, they will exercise their power to hand down a judgment on that particular case. So the decision of reclamations has always been made by the government. Under what circumstances would we have to consult the town planning board? For the 14 harbour enhancement works in the schedule, they don't involve any amendment to any outline zoning plan. We carry out these harbor enhancement works in order to make the harborfront more convenient for the people and allow them to enjoy the harborfront better. And that's one of the ancillary uses of the harborfront. So the list of works under the schedule will not involve any amendment to the outline zoning plan, and I'm sure that members of the public support this move. Even with the streamlined mechanism, we are going to collect views from the members of the public and relevant commissions and councils. I'm not sure if I've answered all the questions. On the point of judicial review, how do you remove this element of uncertainty? We view it this way. For large-scale reclamations or harbor enhancement works that are smaller in scale, in the future, under the legislation, we are going to have different mechanisms. The Chief Executive Council will decide on whether the overriding public need test is fulfilled, and we set out the 3 factors that the Chief Executive and Council have to take into account. There is certainty with the procedures and the flow, and the Chief Executive and Council have to consider various factors, and the factors have already been set out in the bill with the mechanism. I think that the possibility of judicial review will be lowered. We are all concerned about the purview of the town planning board. Say, for example, pier that reshaped the coastline and that changes the area of the Victoria Harbour. Shouldn't we amend the outline zoning plan? Please look at it after the meeting because we want to be clear about that. That would affect the project timeline. We will collect more information after the meeting and we'll report that in the next meeting. You raised a very good question and a great point about the purview of the town planning board if it includes ocean or sea. Usually, OZP cover land users instead of sea or ocean area. We'll give you more details in the next meeting. Yes, please. Please also let us know about non-permanent reclamations. Next, the Reverend Peter Kun. Thank you, Chairman. When the government made their presentation, they said that in June 1997, the 4 sections were enacted, and that gave rise to the problems that we are facing today. Despite this amendment exercise, we're not going to have large-scale reclamations in the Victoria Harbour. I wonder why, before our unification, so many restrictions were put in place. I was rather young back then. Can you let us know why we restrict reclamations in the Victoria Harbour with the 4 sections? A lot of people misunderstood that the court was the one to decide on whether reclamations are allowed. Is it because the legislations back then were not clear enough? That's why we enacted this PHO back in 1997. A lot of my friends from Singapore asked me why we don't have refreshment or kiosks along the harbour front. And I told them that this is not allowed. This is a big problem for us because we want to develop tourism. If I remember correctly, there were comments saying that the vested interests want to protect their views. That's why they advocated for the PHO back in 1997. Can you give us any background information? Why did we enact these 4 sections to restrict ourselves to such an extent that we could not even construct along the coastline in Kai-Tak? To be honest, we don't have that many vessels in the Victoria Harbour. Do we have to be so restrictive with the use or reclamations? Regarding the area in Qingyi, I remember that you initiated the inclusion. Can we release that area because it has nothing to do with Victoria Harbour? I mean the Rambler Channel. You should not restrict yourselves. You said that the government is the one to decide on reclamation. No private organizations can reclaim land. I think that you have to be flexible. And application takes years, and that could waste some of our time. Thank you. A few questions from the member. First, the member asked about the background of the enactment of the ordinance in 1997. As I mentioned, this was a private member's bill. A Legislative Council member moved the relevant bill back then. In the earlier years, there were a significant number of reclamations going on along the Victoria Harbour to form land. The community at that time questioned whether we should continue to allow large-scale reclamations in the Victoria Harbour. That's why the LegCo member moved the relevant private member's bill. The member asked why the area of the Victoria Harbour is so extensive. We'll collect more information after the meeting. The area used to be smaller. I think that a few years upon enactment of the PHO, we extended the area of the Victoria Harbour. Why was Qingyi included? Well, we will research on that, and we will give you a written reply. Please give us information on the size reclaimed in the Victoria Harbour before and after 1997. I remember that there were large-scale reclamations back in those years. Some were inside and some were outside the Victoria Harbour. A lot of people were concerned about reclamations within the Victoria Harbour. You asked about the boundary of the Victoria Harbour. Perhaps the administration can supplement with more information later on. Mr. Stephen Ho. Thank you, Chairman. I agree with Reverend Peter Kuhn's comment. Some people wanted to protect the harbor and some supported the ordinance because of their vested interest. That's why we enacted the Cap 531. With the amendments, there are worries. And some people thought that the government was going to initiate large-scale reclamations by amending the ordinance. I'm glad to see that the government is trying to clear things up, but I think that you should continue your effort in this area. Second, I think that people are concerned about Kennedy Town and the Sai Ying Pun and the West Kowloon Cultural District and Kwun Tong. These are busy channels. Because the harbor has become narrower, and that's why the star ferries become more unstable, and a lot of people have motion sickness because of that. On the point about Rambler Channel, that was a cargo terminal. The sea there was already very narrow. Unless you're relocating the Kwaichong cargo terminal, I don't think that there is any space for you to further reclaim any structures or land there. I support the exemption mechanism for small-scale reclamations, but I think that you should consult the Legislative Council in your course of consultation. You can perhaps write to the panel on development informing us that there will be a small-scale reclamations. Under the old mechanism, let me turn to that page. Under the existing mechanism, the application will go to the Chief Executive in Council. I'm talking about reclamations that are not exempted from the presumption. The threshold is high with large-scale reclamation, but on the right-hand side, the Financial Secretary will decide on whether to grant the exemption. The mechanism is very streamlined, but is that oversimplified? I think that you should at least inform the Legislative Council of the proposed reclamations. You should add that in your flow. I don't have any comments on the large-scale reclamation flow because a decision made by the Chief Executive in Council will be published. You are going to perhaps construct footpath on ocean or boardwalk. You said that private organizations can submit applications. How are you going to deal with the issue of rent? Say I am an owner of a mall. If I want to construct a footpath along the seaside and I said that there is an overriding needs, there's nothing wrong about the private mall owner to want to profit from it, but how are you going to deal with that? The boardwalk could be over on top of the ocean, or could be elevated. Now we have an LNG bunkering station. I don't think that the government is charging any rent from that operator. However, the government is charging fees from fish shaft operators. That's contradictory.
Before I ask the Permanent Secretary to answer your questions, I want to clarify something with you, Mr. Stephen Ho. You are talking about the table on the PowerPoint presentation, right? Yes. For the harbor reclamations not exempted from the presumption and the two other types of reclamations. Thank you. Permanent Secretary, thank you for the projects that would be included in the categories of works on the right-hand side. Whether we will consult the Legislative Council in future, we'll definitely note your suggestion and consider that. For these projects, if they are proposed by a private party, if the area is more than proposed, whether they would be paying land premiums, I believe yes, because it would create value for their land. Before, the Lands Department would often raise the premiums for this reason. I will ask more questions because I am not going to ask a second round of questions. You have been talking about enhancing public enjoyment and enhancing connectivity. You don't really talk about how we can tie in with the development of industries. If you have only promenades in mind, if you want to construct, say, pumping stations in future, people are probably going to object to that. So, can you elaborate on what will be an overriding public need? Because people would always rather have a harbourfront promenade than a pumping station because there are less stakeholders involved for the construction of pumping station. Thank you, Permanent Secretary. For the 14 types of works, it would include the structures that you talked about. For example, some stations, pumping stations for the operations of fishing vessels. While there is a need to supply water for fishermen, there is also the need of citizens to enjoy the harbor front. How can we strike a balance? Let me say this, a facility to supply water shouldn't be of large scale. I think we can really find a win-win proposal after consulting different stakeholders. We can see the facility for the supply of water is not exactly big from the photo here. I believe we can really strike a balance. It is not easy to find a location for pumping stations in Hong Kong, so you can try finding one and suggest one to me. Thank you. Dr. Lo Wai Kwok. Thank you, Chair. Many projects are affected by the ordinance, the alignment, various aspects really, and the Central Kowloon Route project is one particular example. And once the route is commissioned, everyone was saying, why wasn't this project taken forward earlier? If the cost is worthwhile and it is feasible in the works aspect, and if it shows that there is an overriding public need, eventually projects were taken forward, but then the time taken was too long. Before, we had relatively inadequate designs of roads, we had serious congestion, we had poor air quality in certain locations. How can we compensate the residents in these affected areas? With the Victoria Harbour, I understand that indeed we have a much smaller Victoria Harbour than before, so there is really a need to prevent excessive reclamation. But the ordinance prevents the taking forward of smaller scale reclamations as well, which can be beneficial to the public. And the proposed amendments, I believe, are seeking to remove the restrictions rather than helping circumvent the overarching principle of protection of the harbour. I appreciate the government's efforts so far. I think there is no need for the public to doubt the government, and the public should really have trust in both the government and the Legislative Council as a gatekeeper. I want to say this also for smaller scale reclamations. The projects would often cost more than $50 million. So often I expect that the Legislative Council will be consulted unless there are very, very small reclamation projects. So I think members can rest assured. But of course, members will play the role of gatekeepers when scrutinizing the bill's provisions to make sure we are striking a balance between the protection of the harbor and relaxing the restrictions. Thank you. Permanent Secretary, I thank the member for reminding me that there are costs associated with the restrictions in the protection of the harbor ordinance. It's not just about engaging consultants. Since the 2004 and 2008 judgment, the Central Wan Chai bypass project took much longer to complete, and thus the public could only enjoy the benefits after many years. It is a high cost to society. After all, I can see that Mr. Chen Haofeng would like to speak for the second round. But before I ask him to ask his second round of questions, I would like to ask members how we are to invite public submissions. We can either hold a public hearing or invite public submissions, and then I'll let Mr. Chen Haofeng speak. So members, should we hold a public hearing or should we invite written submissions from the public? I would like to hear the members' views on this issue. Mr. Chen Haofeng. Thank you. I believe the issue is of concern to many members of the public. I think holding a public hearing should be the more appropriate option. All right, do members object to a public hearing being held? If there are no objections, we will hold a public hearing. The Secretariat has already found a time slot for the public hearing. The public hearing will be held at 9 in the morning to 1 p.m. on 14th of February. And if a public hearing is to be held, as members decided, it will be held during that time slot. All right, Mr. Chen Haofeng, speaking for the second round. Thank you. I want to ask, with the addition of structures, they will be subject to the new mechanisms, but with the removal of structures, near Cadogan Street before there was an incinerator and the pier was dilapidated, the structure is now barred off. Some would consider it to be historical, but then it is not quite safe either because many would go into the zone. Can the structure be removed? Will it be subject to the mechanism? And if we are to rebuild something after removal, will a separate application be required? Thank you. Permanent Secretary. First, with removal of the relevant structures. We have a definition for reclamation in this bill. Reclamation would have to involve the forming of land. Removal would not involve forming of land, so we believe removal of structures would not be subject to the restrictions under the proposed amendments. But if we are to rebuild something that would involve the forming of land, then it would be subject to the restrictions of the proposed amendments because it would be considered reclamation. And if it meets the relevant requirements, especially if it is the 14 types of one of the 14 types of works, it would be subject to a streamlined mechanism. I want to ask something. So if we are to improve pier facilities, if we are to remove most of it, and we are to enhance the facilities and perhaps have some additional structures, would this be seen as a continuous project, or how would you do the calculations in this regard? Thank you.
好用頭先啊，主席。
If I use the example quoted by the chairman, say there is an existing pier and we remove part of it and build new add-ons to the pier, well, the entire structure should not exceed 0.8 hectares. So the entire structure should not exceed 0.8 hectares. You take into account both the existing pier and the new add-ons. Is that right? Yes. Because most parts of the pier would be on land, not all parts of the land would not all parts of the pier would extend into the ocean or the sea. Say, for example, you said that the sea walls or breakwaters in Causeway Bay are smaller than 0.8 hectares. But there are uncertainties. Are you going to look at the area affected by the construction or the size of the structures? Let me use this slide to explain how we look at the ceiling of 0.8 hectares. Let's look at example 1. Again, we provide for a definition of reclamations under this bill. That is, a land is to be farmed, and the land farmed should be extended from the seabed or foreshore. We will add a definition for seabed and foreshore as well. And that's related to the high water mark, as illustrated on this slide. If pillars are to be constructed below the high water mark, then that would constitute reclamations. The high water mark would be the point where the star is, and the line would be the pillars. And if the pillars is extended below the high water mark, that is below the point of the star, then that would constitute reclamation. For the 0.8 hectares, we apply that to the structure above the high water mark. So we draw a line from the star to above water, and that structure should not extend 0.8 hectares in height. Just now you made some clarifications. You said that the construction site would also be included and would also be accounted for under the 0.8 hectares ceiling. That much is clarified? Yes. Say if there are some new add-ons to the existing structures, we still have to look at the high water mark. We have to see how much of the structure is above the high water mark. But we account for the entire structure, regardless of whether they are existing structures or add-ons. Mr. Chang Hok-fong. Let me give you an example. If we are to reposition the Cadogan Street pier, do we have to make a separate application? If it's a repositioning project, would that constitute a new project? Ms. Ho, if we're talking about refurbishing an existing structures and that structures would not be relocated, then no land would be formed. I don't think that fall within the purview of this ordinance, and that would not constitute reclamations under the ordinance. Say if you're only refurbishing the internal area of the structure, there could be different scenarios that you may come up with. What about refurbishing the structures? Well, let's go back to the definition. We have to look at whether any land is formed, whether any pillars is extended above the high water mark. The piles are extended above the high water mark. What if I am redeveloping or refurbishing an existing structures? Do I have to make a new application for it? Say, for example, if you are reinforcing the strength of the piles, do we have to make a new application? Chairman, let me try to answer this question. If the project proponent is just reinforcing the structure and that involves putting in place new piles, again, if the piles put in place is above the high water mark, then that would fall under the purview of the ordinance. If you want to go for the streamlined mechanism, the new piles should not be larger than 0.8 hectares. Dr. Lo Wai-kwok, thank you. I also have some questions regarding the 0.8 hectares ceiling. Are we talking about the construction site area, or are we talking about the size of the new structures? A lot of members have asked about repair and maintenance. If no new land is formed, then there shouldn't be any problem. But I have some doubts regarding the reinforcing structures not exceeding 0.8 hectares. Just like what the members asked, if I'm just adding on some new structures, you count the entire new structures, including the old and existing one and the new ones, as a structures under the new legislation, and that should not exceed 0.8 hectares. I have doubts about that. Let's go back and think about that. Well, regarding the 8 hectare ceiling, are we talking about the size of the new land formed or the construction site area? Let me use these two examples. There are 2 piles that have been erected from the seabed, and a bridge is formed. The surface area of the bridge should not exceed 0.8 hectares under the streamlined mechanism. Some people are concerned about the shape of the reclaimed structures. I'm sure that the Financial Secretary would look into the application, but the shape of the reclaimed structures may affect the Victoria Harbour and the official appeal of it. So some shapes may not be appropriate. On non-permanent reclamations, there is a time limit. If the project proponent cannot reinstate the harbor within the specified time frame, what would be the consequences? What are the responsibilities of the specified officer? Thank you. On your first question about the shape of the 0.8 hectare structure, I understand your concern. In the future, when we formulate our guidelines, we will set out clearly that the Financial Secretary will look at the shape of the reclaimed structure and how it affects our harbor. We can handle that when we draft our guidelines. Second, you asked about the what if the specified officer cannot reinstate the harbor after the specified timeline? Well, I'm asking about whether there is any penalties or if there is any consequences. Under our bill, we don't provide for any penalties on the non-compliance of any specified officers. Well, if that happens, then we will invoke the Civil Service Code or relevant guidelines to handle that. Some of the works may be outsourced to the contractors. So we may have to look at the agreements between the contractors and the government. Say if within the specified time frame, the specified officer cannot complete the project or complete the works, we don't think that is going to happen because we do have a mechanism asking the specified officer to submit a progress report to the Financial Secretary so that the FS will know whether the works can be finished within the specified time frame. If there's any problem, we can take action early to make sure that the works can be completed within the time frame. We don't think that is likely to happen, but when that happens, there is mechanism for us to handle that. The Financial Secretary can give direction as to how it is going to be dealt with, but we haven't provided for any penalties under the legislation. We will handle that under the civil servants appraisal system. Maybe you should set out the relevant responsibilities and the agreement between the contractors and the government. Please look into it. Our meeting was scheduled to end at 6:30 p.m. Mr. Chen Hofeng would like to speak again. I will extend the meeting until you have asked your questions and the government has given their reply. After that, our meeting will conclude. Thank you. You said that 0.8 hectares include existing and new structures. If the remaining old structures is larger than 0.8 hectares, then after it's demolished, you cannot really add on any new structures to it. Is that right? Are we only accounting for the horizontal plane of the structures? What if the project proponent built a few stories above it? Would that be possible, Ms. Ho?
On your second question, we only count the ground floor area, and indeed, one can have multiple stories constructed, but since the site is in the waterfront, I am sure no one wants to see a high density structure, multi-story structure constructed right before the harborfront, and the financial secretary will have due consideration of this. And if you're talking about the existing structure being over 0.8 hectare and they have removed the structure and put in place a new structure that also exceeds 0.8 hectare, it's not that they can't take forward this project, but it's just that they won't be entitled to the streamlined process. Thank you. All right, that ends the deliberations today. Let me also remind members the next meeting will be held on the 20th of January, Monday at 10:45 in the morning. I ask members to attend the meeting punctually. If members have no other business to propose, meeting adjourned.